First, the breadth of the bail-in legislation poses real challenges for banks. Examples of contractual liabilities that have been identified by the LMA as included within the scope of the bail-in legislation include loan commitments by the institutions, indemnities given by the institutions, for example, to an indemnity given to an administrative agent or a collateral agent in a loan or credit agreement. The requirement to share recoveries from that an institution receives from a borrower with other institutions is covered. They've identified confidentiality obligations as subject to the bail-in legislation. Any restrictions on creditors' actions under intercreditor agreements, and even potential negligence and misrepresentation claims are covered, according to the LMA. So you'll note that this list includes a variety of items where a financial institution might expect to have zero liability, or where liability only comes about because a financial institution has breached its obligations or been negligent. So what is a financial institution to do? It puts them in a quandary because the number of agreements that are purportedly covered could be very, very, very broad. And so in response to this, some jurisdictions, notably the UK, have created a rule which states that if a financial institution determines that it's impracticable to comply with the legislation and the determination is reasonable, then they have the right to not comply with the legislation and can conduct their business in the ordinary course. And the challenge for the financial institution is that it must be able to defend its decision on impracticability to the regulators. So examples that the UK has identified of situations where it would be impracticable to comply include situations where the bail-in provisions would violate the laws of another country or be prohibited under those laws. And so therefore, including a bail-in provision would subject you to potential penalties under local law of another jurisdiction. If the financial institution is entering into contracts that impose liabilities that are governed by international protocols, where the financial institution itself doesn't have the ability to amend those protocols. If the financial institution is party to form agreements by reason of its membership in an international organization, and it doesn't have the unilateral ability to amend those form agreements, that's another situation where one could conclude that it's impracticable to include the bail-in provisions in the contracts. Further, the UK has identified specifically the situation where a financial institution would only be liable by reason of its breach of a contractual obligation as a situation where inclusion of those provisions is potentially impracticable. So this remains a developing area. The banks and financial institutions should monitor it. Clearly, the UK will be coming out with more regulatory guidance on this, and it's an area that we're all watching very closely.